Welcome, everyone, and thank you for joining us today. This is 1 year of patent law in 60 minutes. My name is Jason Hoffman. Presenting today alongside me is Mike Anderson. We are both patent litigation partners resident in BakerHostetler's Washington, D.C. office. Our program today will last 60 minutes and is approved for 1 hour of CLE credit in California, New York, and Pennsylvania. For all other states, credit will be applied for as requested. Twice during the presentation, a CLE code will appear on your screen. If you are seeking CLE credit, please make sure to write down these codes. At the conclusion of this presentation, you will be asked to fill out a CLE form in which you will need your bar number and the 2 CLE codes. If you have any questions during the presentation, you can submit them through the Q&A button in the bottom of the navigation bar. We will try our best to answer them at the end of the program, time permitting. If not, we will follow up with you via email after the webinar to answer them. Let's get started. This is a quick overview of patent decisions by the Federal Circuit during 2020. The court issued 458 patent-related decisions. Of these, 116 were identified by the court as precedential opinions. Mike and I read all 116 cases, plus a few others. During the course of this hour, we will touch on around half of those decisions. For today's webinar, we have organized the cases into 6 topics. They are venue and jurisdiction, claim construction and infringement, Section 101 eligibility, invalidity, remedies, and finally, PTAB practice. So let's begin with venue and jurisdiction. This chart identifies the total number of district court patent infringement cases filed each year since 2015. 2020's number was 3,959 cases. What we see from this chart is that the downward trend in new patent cases filed over the last 5 years is starting to reverse course. Where are these new patent cases being filed? In 2020, the Western District of Texas rocketed to the top of the list, with Delaware a close second. Why the Western District of Texas? The Western District of Texas has one judge who sits in Waco, Texas. His name is Judge Alan Albright, and 20% of all patent cases filed in 2020 were filed before Judge Albright. This equates to a total of 792 cases in 1 year. Why Judge Albright? He has made it known that he wants patent cases. And because he is the only judge who sits in Waco, a plaintiff who files in Waco is guaranteed to get Judge Albright. I point all of this out because the Federal Circuit has decided 10 writs of mandamus in the last 12 months that originated from Judge Albright. Writs by their nature are rare, and they are rarely ever granted. These cases give some insight regarding what is going on in Waco and how the Federal Circuit is handling it. There have been 8 writs of mandamus filed relating to motions to transfer out of Waco, Texas. In the Apple case, Judge Albright denied a motion to transfer to California, but granted the motion for an intra-district transfer to Austin, where Judge Albright would still preside over the case. Apple appealed, and the Federal Circuit denied the writ. 1 month later, in Adobe, Judge Albright again denied a motion to transfer to California. The Federal Circuit granted the writ, saying that Judge Albright abused his discretion. The Western District of Texas was not convenient for the parties or the witnesses. In the Dropbox case, it involved the same plaintiff as in the Adobe case and was issued the same day. The Federal Circuit denied the writ, but told Dropbox to file a motion for reconsideration with Judge Albright in light of the Adobe decision. Dropbox did, and that motion for reconsideration has been now pending for over 6 months. In nitrofluids, the Federal Circuit found that the Judge Albright did not properly apply the first to file rule. A case had previously been filed in the Southern District of Texas. It involved the same parties, the same accused products, and related patents. The Federal Circuit vacated his decision and asked Judge Albright to renew his analysis. To date, Judge Albright has issued a Markman decision, but almost 4 months later has not yet ruled on the pending motion to transfer. But wait, there's more. In a different Apple case, the Federal Circuit granted the writ and forced transfer of the case to California. Notably, the Federal Circuit appeared troubled by Judge Albright sitting on the motion to transfer. He held a hearing on Apple's motion, during which the court stated it would deny the motion and issue a written order as soon as possible. But after the hearing, and before issuing the written order, the court held a Markman hearing, issued a claim construction order, held a discovery hearing, and issued a corresponding order. And only after Apple filed its writ did Judge Albright issue his order denying transfer. In the Intel case, Judge Albright previously transferred the case to Austin, where he still presided over the case. The Austin courthouse is closed for COVID. Judge Albright, sua sponte, transferred the case back to Waco because his courthouse is open and scheduled the trial for January 2021. The Federal Circuit granted the writ and stated that Judge Albright had failed to perform the correct analysis for retransferring the case back to Waco. In the second Intel case, Judge Albright reissued his sua sponte transfer motion back to Waco and scheduled the trial for February 2021. The Federal Circuit denied the second writ, stating that while it may disagree with the order, it was not an abuse of discretion. The trial in that case started on Monday. Finally, in the SK Hynix case, the motion to transfer had been pending since May 2020, and Judge Albright had yet to rule. SK Hynix filed its writ, and then Judge Albright scheduled a hearing on the motion to transfer. The day before the hearing, the Federal Circuit granted the writ, stating that Judge Albright's, quote, handling of the transfer motion up until this point in the case had mounted to egregious delay and blatant disregard for precedent. The Federal Circuit granted a stay of the case until Judge Albright ruled. Judge Albright has now denied the motion to transfer, and SK Hynix has appealed that ruling. Another reason plaintiffs may be filing their patent cases in Waco is because Judge Albright has denied all motions for stays pending the outcome of an IPR or a PGR in the Patent Office. Those denials of stays have been twice appealed to the Federal Circuit via a writ, and twice have been denied. These are all issues to keep in mind for both plaintiffs and defendants in Waco. Moving on to other jurisdictional issues, the Schweidemann case concerns the issue of standing, and specifically what happens if the patent assignment contained an error. Does that error mean that the patent holder loses standing? Usually the answer is, of course it does. But in this case, the assignment was retroactively corrected after the lawsuit was filed. Applying state law principles of contract reformation, the Federal Circuit held that the plaintiff did not lose standing, even though the assignment was corrected after the lawsuit was filed. Turning to the Ginsetics case, is the owner of a patent a necessary party when that owner happens to be a state university? Here, the University of Texas licensed a patent to Ginsetics, and then Ginsetics turned around and sued Baylor. UT wanted no part in suing Baylor. Ginsetics then added UT as an involuntary plaintiff. The district court dismissed UT from the case based on UT's sovereign immunity, and then dismissed the lawsuit entirely, ruling that UT was a necessary party for Ginsetics to maintain standing. The Federal Circuit reversed. It agreed that UT could not be involuntarily joined due to its sovereign immunity, but decided that UT was not a necessary party because UT's absence from the lawsuit did not pose a substantial risk of multiple suits. The Antenesis case concerned an interesting issue regarding standing and joint ownership of patents. Does one co-owner of a patent have standing to file suit without the other co-owner of the patent? The Federal Circuit held that the short answer is no. An action for infringement must join as plaintiffs all co-owners of a patent, unless the absent co-owner has granted an exclusive license to the other co-owner or waived his or her right to refuse to join the lawsuit. A non-consenting co-owner can never be involuntarily joined to the lawsuit because the right of a co-owner to impede an infringement suit brought by another co-owner is a substantive right under 35 U.S.C. Section 262, which provides that each joint owner of a patent has separate rights to the patent. Usually, a second filed suit will be dismissed when there's a first filed suit. In communications test design, that was not the case. Here, the alleged infringer had raced to the courthouse, as it was in negotiations with the patentee, and was the first to file a case. This declaratory judgment action was dismissed in light of the patentee's second filed suit. The Federal Circuit affirmed the dismissal, explaining that district courts enjoy a double dose of discretion. Discretion to decline to exercise jurisdiction over a declaratory judgment action, and discretion when considering and applying the first to file rule and its equitable exceptions. Finally, we turn to the venue in an ANDA cases. Where do acts of infringement under Section 1400B occur with regard to infringement claims brought under the Hatch-Waxman Act? The Federal Circuit held that infringement occurs only in the district related to the submission of an ANDA and not in districts where the future distribution of the generic products is contemplated. Does infringement also occur in Maryland, where the FDA is located and where the ANDA submission is received? The Federal Circuit left that issue undecided. And now we turn to claim construction and infringement. Mike?
Thank you, Jason. Patent practitioners are familiar with the maxim that a patentee can be his or her own lexicographer. And it's fairly common for parties to argue during claim construction that the specification provides a definition of a term. The Buxalta case that we have here serves as a warning that even where the specification appears to contain a definition, it may not actually be adopted by the court as a construction if the term is used inconsistently with the claims or other portions of the specification. Here, the district court had construed the term antibody based on what it viewed as a definition, and you can see the statement there from the specification. The Federal Circuit disagreed. They said, we read this passage as a generalized introduction to antibodies rather than as a definitional statement. The Federal Circuit stressed that the specification must be read as a whole and that this definition was inconsistent with other portions of the spec as well as the claim language. So if you're a defendant, a takeaway from this may be that if the descriptions in the specification are not consistent, you may wish to consider pursuing indefiniteness rather than a specific construction. Moving to the e genera case, here the district court construed a term as being means plus function, even though the word means was not used. The claim required logic to modify said received messages to transmit said modified messages to the external communication network and the external storage network. The Federal Circuit agreed that the logic to modify language was simply a substitute for the phrase means for. The Federal Circuit noted that while there's a presumption that a claim that does not use the word means is not means plus function, that presumption is weak. And they said it had been rebutted here because the claim did not recite sufficient structure for performing the function. It was merely a black box. A couple of decisions came out on the same day in 2020 in which the Federal Circuit relied heavily on statements made during prosecution to interpret claims. First, in personalized media, there was a dispute over whether the term encrypted digital transmission, including encrypted information, required that all or only some of the information being transmitted be digital. The Federal Circuit said that the claim language and the specification could support either construction, but said that the applicant's repeated statements during prosecution made it clear that the claims were directed to an entirely digital process. The Federal Circuit emphasized that even where prosecution history statements don't rise to the level of an unmistakable disavowal, they still inform claim construction. The second case that we have here is Kaken Pharmaceutical, where the Federal Circuit concluded that the PTAB had erred in construing the term treating a subject having onychomycosis, a form of nail fungus, and erroneously concluding that it covered infection of any structure of the nail. The Federal Circuit said that the patent owner's statements and the examiner's responses made it clear that the scope of the claim was more narrow. The applicant had specifically argued the disease affects the nail plate and that the invention has the ability to penetrate the nail plate and be retained by the nail. The examiner's notice of allowance similarly said that the method penetrates through the nail plate. There are also a couple of interesting decisions on indefiniteness in 2020. First, in the Nevro v. Boston Scientific, the claims had been directed to a high-frequency spinal cord stimulation therapy for inhibiting pain. The claims required a paresthesia-free system. Paresthesia is essentially the pins and needles sensation that you might get. The district court held that the asserted claims that related to systems and devices were indefinite because they depended on the effect the system had on the patient, and therefore infringement would need to be determined on a patient-by-patient basis rather than as a result of the system or device itself. The Federal Circuit reversed and said that the district court applied the wrong standard. Whether you have to individually assess infringement is not important. The test for indefiniteness is simply whether a claim informs those skilled in the art about the scope of the invention with reasonable certainty. The second case that we have here, IBSA, presents an example where what might have been a bad translation leads to an invalid patent. The patent had covered a thyroid hormone medication that contained a claim directed to a capsule having a half-liquid phase. The patent had claimed priority to an earlier Italian application that used the term semi-liquido or semi-liquid. The Federal Circuit concluded that half-liquid, that phrase, was indefinite, and it said that the term had not been defined in the specification or the prosecution history. So the bottom line is be careful about your translations. Moving next to a couple of cases that came out involving design patent infringement. You can see from the pictures that we put up here that what constitutes infringement of a design patent can be based on some relatively fine distinctions. In the first case, there was infringement, and this is the Hafco v. GS Mine Repair. The accused product was a rock dust blower, and the defendant had appealed a finding of infringement based on a jury instruction that said infringement of a design patent is based on the ordinary observer's perspective, and that minor differences between the device and the drawing do not prevent a finding of infringement. The Federal Circuit affirmed the jury's finding of infringement and found no error in the jury instruction. In the second case, Leonard Toys, the issue was chalk pencils, or the technology was chalk pencils. The Federal Circuit affirmed summary judgment of no infringement, stating that there were ornamental differences between the accused product and the claimed design, and that the design similarities stemmed from aspects of the design that were functional or well established already in the prior art. The court also said it was improper to compare the defendant's product to the plaintiff's product in assessing design patent infringement. TCI Communications addressed the issue of infringement of standard essential patents. In the Fujitsu v. Netgear case, the Federal Circuit had previously stated that if an accused product operates in accordance with the standard, then comparing the claims to that standard is the same as comparing the claims to the accused product. The parties here disputed who should determine whether a patent is essential and when that should happen. Specifically, should it be part of the court's claim construction or should it be part of the trier of facts infringement determination? The Federal Circuit held that the determination of standard essentiality of any asserted patent claim is the domain of the trier of fact, either the jury or the judge on summary judgment, and that should be part of the infringement analysis. The next case is CR Bard, and it's an interesting one because it discusses what evidence the plaintiff may rely on to prove infringement. The technology at issue related to vascular ports that you have under the skin that allow the injection of fluid into the veins without starting a new IV. Partway through the trial, the district court had granted judgment as a matter of law of non-infringement. It said the plaintiff had failed to conduct its own tests demonstrating that the defendant's products practiced the claims, and instead had merely relied on the defendant's statements to customers in the FDA. The Federal Circuit reversed the grant of judgment as a matter of law and remanded the case. It stated that a plaintiff is entitled to rely on a defendant's representations to customers in the FDA regarding how the product operated, and that that evidence was substantial evidence on which a jury could rely to find a verdict of infringement. The court also addressed the issue of inducement, and it noted that the plaintiff is not required to present direct evidence of specific instances where an entity performed all the claim steps of a method claim in order to directly infringe. That an alleged infringer designs a product and instructs a user to use it in an infringing way is sufficient evidence to find direct infringement that's necessary to support a finding of inducement. The court also noted that the existence of an opinion of counsel is not itself dispositive on the issue of willfulness. The Eagle Pharmaceuticals case on this next slide presents an issue of the disclosure dedication doctrine. The disclosure dedication doctrine is an exception to the doctrine of equivalents. When a patentee discloses subject matter but doesn't claim it, he or she dedicates the unclaimed subject matter to the public and can't recapture it through the doctrine of equivalents. So here, the patent owner had asserted that the defendant infringed under the doctrine of equivalents because the ethanol in the defendant's product was insubstantially different from the propylene glycol that was claimed. The specification had specifically stated that acceptable fluids included ethanol, but ethanol was not claimed. The Federal Circuit agreed that ethanol was an unclaimed alternative and affirmed a finding of non-infringement under the disclosure dedication doctrine. Moving on to the issue of willfulness, the Texet case was a case that came up on appeal to the Federal Circuit a second time. The first appeal had come to the Federal Circuit after the parties had stipulated to non-infringement under the district court's claim construction. The Federal Circuit vacated that construction in the first appeal. During trial on remand, the district court granted the defendant's motion in limine and excluded deposition testimony related to the issue of willfulness. The district court reasoned that its prior ruling had made it impossible for the defendant to have knowingly infringed after the date of the court's prior construction. The Federal Circuit disagreed. The Federal Circuit said willfulness is based on subjective knowledge, and Adobe, the defendant in that case, may have had such knowledge if it believed, as the Federal Circuit ultimately concluded, that the district court's claim construction was incorrect. So even if that construction had been objectively reasonable, if the defendant didn't actually believe it was correct, they could still be liable for willfulness. The last case I wanted to discuss in this section presents an issue of res judicata. The plaintiff had filed two cases against the same defendant, and the district court had dismissed the first case with prejudice for failure to prosecute. The district court concluded that res judicata barred the second case, and the Federal Circuit agreed. It said that res judicata may be based on a dismissal for failure to prosecute, and it also rejected an argument that res judicata could not apply to new claims of infringement that occurred after the conclusion of the first case. Federal Circuit stated that preclusion may apply to claims even if they arise after the prior judgment. It said, when an act has been adjudged not wrongful, its repetition cannot be challenged in a subsequent suit. At this time, it's our first CLE code, BH2021A. Please write that down. You'll need to enter it at the end of the presentation to qualify for CLE credit.
All right, thank you, Mike. And now we move on to patentability and section 101. It's time to run through a series of decisions where the Federal Circuit tells us what is and what is not patent eligible under section 101. The first two cases involve diagnostic claims, which are generally not patent eligible. In CardioNet, the patent related to a cardiac monitoring device for detecting the presence of atrial fibrillation or flutter. The district court had ruled that the claims were directed to the abstract idea of atrial fibrillation and flutter, and flutter and can be distinguished by focusing on the variability of the irregular heartbeat. But the Federal Circuit disagreed and found that the claims were not directed to an abstract idea because they were directed to an improved cardiac monitoring technology that achieves speedier and more accurate detection of these heart conditions over prior systems. In Illumina, a mother's bloodstream carries fetal DNA, and there is no known way to distinguish and separate the tiny amount of fetal DNA from the vast amount of maternal DNA. Here, the inventors have figured out how to identify the fetal DNA by removing longer DNA fragments, which were maternal DNA, from shorter DNA fragments, which were the fetal DNA. While it is a natural phenomenon that fetal DNA tends to be shorter than maternal DNA, the Federal Circuit held that this method amounted to more than testing for the natural phenomenon. The Federal Circuit stated that this was not a diagnostic case, which would make it patent ineligible. It was also not a method of treatment case. Instead, it was a method of preparation, which then made it patent eligible. The next two cases focus on the technological improvements over the prior art, which make the claims patent eligible. The issue in the XY case was whether the claims simply covered a mathematical formula. The technology is used to separate X from Y-bearing sperm, which is used in animal husbandry to guarantee the sex of offspring. The claims were directed to an improved method of sorting individual particles in the same sample in real time. The district court had held that the claims are directed to a mathematical equation that permits rotating multidimensional data. The Federal Circuit disagreed. The asserted claims describe in detail a step-by-step method for accomplishing a physical process, and that at least two sensors gather data about an object, which generates more accurate information about the object than was previously possible in the art. And this was done before the mathematical operations were applied. Thus, it was patent eligible. In the Unilock case, the claims are directed to a system that allows a computer to talk to a mouse or a keyboard. In a conventional system, the computer sends out an inquiry message to see if the mouse has information to send back to the computer. If the mouse is in a low-powered parked mode, the mouse will not respond until the computer sends a separate polling request, which then wakes up the mouse. The invention improves this system by having the inquiry message also include a polling request. The Federal Circuit found this to be patent eligible because the claims reduce the delay present in conventional systems where the computer alternates between sending inquiry messages and polling requests. In American Axle, the Federal Circuit issued a rare split decision in a 101 case. The issue was whether the claims were directed to Hooke's law, which is an equation that describes the relationship between an object's mass, its stiffness, and the frequency at which the object vibrates. Claim 22 was directed to a method of manufacturing propeller shafts with a liner and tuning that liner to attenuate vibration transmitted through the shaft assembly. The Federal Circuit found that the claim was simply directed to the utilization of Hooke's law, without the benefit of instructions on how to do so. Now, the only difference between Claim 22 and Claim 1 was that the liner was used to attenuate at least two types of vibration. And with Claim 1, the district court had construed the claim to mean controlling characteristics of the liner to reduce at least the two types of vibration. The specification disclosed that the characteristics that could be used to do the tuning, including variables other than mass and stiffness, which were the lone variables implicated by Hooke's law. Because of this construction, the claim is not merely directed to Hooke's law, and thus Claim 1 was found to be patent eligible. A petition for rehearing en banc was denied 6-6. We'll have to see if the Supreme Court grants certiorari on this one. In Ericsson, the claims were directed to a system for securing mobile phones against improper access by apps. The claim elements include an interception module for receiving a request for access and a security access manager for determining if the request should be granted. Under step 1, the Federal Circuit found that the claims were directed to an abstract idea of controlling access to or limiting permission to resources. For step 2, the Federal Circuit found that the bulk of the claim provides the abstract idea, and the remaining limitations provide only necessary components. Erickson had argued that the inventive concept of the patent lies in a particular 3-layer arrangement of software. However, the Federal Circuit rejected the argument because that while the alleged inventive concept was present in the specification, that concept was not recited in the claims. This is a delivery notification patent using mobile devices. The claim monitors the location of a delivery person, notifies the recipient in advance of the arrival, and allows the recipient to communicate with the delivery person. The Federal Circuit found this claim to be not patent eligible. The claim was directed to the abstract idea of providing advance notification of delivery, which is a long-standing commercial practice. Under step 2, there was no inventive concept. In CX Loyalty, this patent permitted a customer of a loyalty program to redeem loyalty points using a graphical user interface and transfer that information using an application programming interface. The Federal Circuit held that the claim was directed to the abstract idea of facilitating such a transaction via transfers of information. Humans have long intermediated these very transactions by collecting and relaying the very same information. And under step 2, the claims amounted to nothing more than applying the abstract idea to conventional techniques. In custom media, the claims related to advertising on your cable box and allowing for those advertisements to be monitored and controlled remotely to deliver specific advertising. The Federal Circuit found the claims were directed to the abstract idea of using a computer to deliver targeted advertising to a user and not an improvement to the functioning of a computer. Under step 2, the claim simply uses a computer to provide the abstract concept. In the Bozeman case, the claims were directed to a method for authorizing and clearing financial transactions to detect and prevent fraud. And that included receiving data from 2 financial records, storing that data, comparing that data, and displaying the result. The Federal Circuit found that the claims were directed to the abstract idea of collecting and analyzing information for financial transaction fraud or error detection. The claims included using a digital scanner to create an electronic record of a check, but this did not meet the machine or transformation test, and thus there was no inventive concept under step 2. And finally, our last case in the 101 section, you can't patent a method for selecting a fishing hook based upon observed water conditions. Here, a human observes the clarity of the water, measures the light transmittance of the water, and selects the right colored hook. The Federal Circuit found that the mental process of hook color selection demonstrates that the claim as a whole is directed to an abstract idea.
Thanks, Jason. There are a large number of cases from 2020 that involve some form of an invalidity issue, but many of them are based on very specific facts or the disclosures of specific references. In this next section that we'll talk about, we try to focus more on cases that involve general concepts of invalidity. Starting first with the Donner Technology case, this case involved claims directed to a guitar effects pedal board that you could modify, the user could modify to add new guitar effects. The Federal Circuit had vacated the PTAB's finding that the claims were not obvious because it said the PTAB had applied the wrong standard in determining that a prior art patent, which had been directed to electrical relays, was non-analogous art. Federal Circuit said there are 2 steps for determining whether art is analogous. First, whether art is from the same field of endeavor, regardless of the problem addressed. And second, if the art is not from the same field of endeavor, whether the reference is still pertinent to the problem to be addressed. Well, it was agreed that the first test did not apply here. The Federal Circuit found that the PTAB had erred in failing to properly consider the second test, and it had failed to properly identify and compare the purposes and problems of the prior art. The next case, BASF, involved questions of public use. Section 102A's prior knowledge or use means knowledge or use which is accessible to the public. The district court had granted summary judgment of validity based on its conclusion that the prior art was not accessible to the public as the result of a confidentiality agreement. Federal Circuit reversed that and noted that the mere existence of a confidentiality agreement is not dispositive on the issue of, of public knowledge and accessibility. The existence of the agreement and the extent to which it's honored or enforced by the parties are merely evidence to be considered, and neither is conclusive on the issue of public accessibility. The GS Cleantech case presents a very interesting issue of inequitable conduct. Ever since Therasense, it's been very difficult to succeed on inequitable conduct claims. In GS Cleantech, the Federal Circuit affirmed a finding of inequitable conduct because it found that the patentee had failed to disclose information that would have implicated the on-sale bar. A patent is invalid under the on-sale bar if before the critical date, the invention was the subject of a commercial sale or offer for sale, and it was ready for patenting. Here, GS Cleantech had made a proposal prior to the critical date, which the district court concluded qualified as an offer for sale under the UCC. The district court further found that the product was ready for patenting based on testing that had been performed by the patentee and the depiction of the invention in drawings and other materials in a manner that would have allowed the person of ordinary skill in the art to practice the invention. Now, the Federal Circuit here found evidence that the omissions were material and intentional, which is normally very difficult to prove. The Federal Circuit found that the patent owner had knowingly withheld evidence of successful testing from the PTO, and it had in fact attempted to coerce the recipient of the proposed sale to admit that the patent was valid by offering them a royalty-free license in exchange for certain statements related to the offer. The Federal Circuit did not view that particularly kindly. Moving to the next decision, Amgen v. Sanofi, this is really a very important decision that issued earlier this month on enablement. The case concerned two related patents that claimed antibodies for binding to certain proteins and lowering LDL cholesterol by blocking those proteins from binding to LDL receptors. Here, the antibody claims were defined by their function of binding to the target proteins. The jury had found that asserted claims were not invalid for lack of enablement or written description. The district court disagreed, however, and granted judgment as a matter of law on lack of enablement. The Federal Circuit ended up agreeing with the district court. Now, the patent included 26 different examples of antibodies, and while the parties debated about the total number of possible antibodies, whether it was hundreds or even millions, the court noted it really didn't matter either way because regardless, a great deal of trial and error work would be required to locate additional antibodies. The court went through a detailed discussion of the Wands factors on enablement, but it essentially summarized the analysis with an analogy to a piece of land. If the claims were a piece of land, then the amount of guidance provided would sit in just a small corner of the lot, according to the Federal Circuit. Now, this case has a potential to dramatically change what's been a somewhat common practice of defining biologics by the target to which they bind. So it could impact a large number of patents that have already issued. Amgen does have the right to potentially seek en banc review or review by the Supreme Court. So this will be a case to keep an eye on as time goes on. We briefly wanted to just touch on the Biogen and the Uber technology cases. Biogen involved a product by process claim, and more specifically, it involved claims that required or claims that related to a drug whose composition was already known, required that it be made by a recombinant process. The Federal Circuit made relatively short work of that claim, noting that a new process of manufacture does not make an old product made by that process novel. The Uber Technologies case vacated a PTAB finding that certain claims were not obvious. I wanted to mention this case because it directly addresses an argument that's often made in arguing against obviousness, and that's that prior art references would not be physically combinable. Here, the Federal Circuit specifically noted that it is not necessary that two pieces of prior art be physically combinable to render obvious the asserted patent. The last case I wanted to discuss in this section is Hologic v. Minerva, which concerns Assignor Estoppel issues. Assignor Estoppel is an equitable doctrine that prevents one who has assigned the rights to a patent or patent application from later contending that what was assigned is a nullity. Here, the plaintiff Hologic had required two patents in suit from a company that had purchased those patents and, in fact, the entire company from one of the co-inventors of the patent. The co-inventor had gone on to found a new company, Minerva, which Hologic subsequently sued for infringement. Now, Minerva was able to successfully challenge one of the patents in an IPR where Assignor Estoppel does not apply. The district court then allowed Minerva to argue, based on the IPR decision, that the claims of the first patent were invalid. But Minerva could not argue that the claims of the second patent were invalid because it was barred by Assignor Estoppel. Now, interestingly, the Supreme Court has granted cert on the issue in this case of whether the defendant in a patent infringement action who is assigned a patent or who's in privity with an assigner of a patent may have a defense of invalidity heard on the merits. So this case may be revisited by the Supreme Court shortly. At this time, we have our second CLE code, which is BH2021B. That's BH2021B. You'll need to enter this to obtain CLE credit at the end of the program.
All right, thanks, Mike. Now we're going to go on to remedies. Can you win on infringement, but be awarded 0 damages? The answer is apparently yes. In this case, the jury found direct infringement, but did not find indirect infringement. But the damages presented at trial were all tied to indirect infringement theories, and the plaintiff had presented no evidence of damages resulting from direct infringement. The Federal Circuit held that even though the damages statute states that the plaintiff shall be awarded no less than a reasonable royalty, that the statute does not require an award of damages if none are proven that adequately tie a dollar amount to the infringing acts. $3.8 billion. That was the total sales volume of the defendant's accused product. The jury was not only told this number, but was also told that the total damages were, quote, pennies on the dollar, and that the total damages amounted to a small portion of the defendant's profits, which are in excess of 75% of its sales. The Federal Circuit found that these comments were improper. However, the references to $3.8 billion was proper in itself because the royalty base used by the damages expert was in fact total sales, which was then multiplied by the royalty rate. But on the whole, the Federal Circuit found that these improper comments were not so prejudicial as to require a new trial. The $89 million verdict was affirmed by the Federal Circuit. While there is a federal statute governing the interest rate for post-judgment interest, district courts have discretion regarding the proper interest rate for pre-judgment interest. The significance of this case is that the Federal Circuit affirmed a pre-judgment interest rate of 10% per year, which is certainly a very high interest rate. The district court had chosen this rate based upon a Minnesota state statute. And because the jury had awarded damages as a lump sum, the Federal Circuit held that pre-judgment interest was properly applied to the entire amount beginning on the first date of the infringement. So on a damages verdict of $2.6 million, the plaintiff collected an extra $1.9 million in pre-judgment interest. The Federal Circuit issued a number of decisions in the last 12 months involving attorney's fees. In the O.F. Mossberg and Sons case, It was stayed pending an IPR. After the defendant successfully invalidated the patent via the IPR, the plaintiff voluntarily dismissed the case under Rule 41A1A(i). That dismissal does not require a court order. As a result, it was not a final court decision, and without a final court decision, the defendant was not a prevailing party, and thus not entitled to attorney's fees. The Keith Manufacturing case also involved a dismissal. This was a joint stipulation of dismissal with prejudice under Rule 41A1A(ii). But the stipulation was silent with respect to costs and attorney's fees. Then the defendant filed a motion for attorney's fees, and the Federal Circuit held that a stipulation of dismissal with prejudice does not preclude attorney's fees. The lesson here is, if you stipulate to dismissal of a case, be sure to indicate that each side agrees to bear its own costs and attorney's fees. Here are two more cases on attorney's fees. In the first, the Federal Circuit reversed a finding of attorney's fees. The district court said that the plaintiff should have been aware of the weakness of its patent validity, which was based upon the plaintiff's proposed claim construction. The Federal Circuit said that the issue when determining fees was not whether the proposed claim construction was correct. Rather, the relevant question is whether it was reasonable. In the second case, the district court denied a motion for attorney's fees. The Federal Circuit vacated that decision, finding that the district court had failed to address the plaintiff's manner of litigation and the broader conduct of the plaintiff in other lawsuits. Here, the plaintiff had sent out standardized demand letters and had filed lawsuits against at least 150 defendants and demanded low-value settlements ranging from $15,000 to $30,000. Keep these facts in mind the next time you get a demand letter. And in our last attorney's fees case, can you recover in district court attorney's fees associated with the filing of an IPR? The short answer is no. The Federal Circuit found there was no basis in the Patent Act to collect attorney's fees for filing an IPR. Turning to injunctions, at a trade show, BlephX told potential customers that Myco infringed its patent. Myco responded with a DJ action against BlephX. Myco moved for a preliminary injunction to enjoin BlephX from accusing Myco of infringement in the marketplace and also from threatening litigation against Myco's potential customers. The court issued the preliminary injunction. The Federal Circuit reversed, explaining that you can't restrain somebody's speech without a finding of bad faith. In addition, the court found that there was no adequate basis to conclude that the allegations of patent infringement would be false or misleading. The Biorad case involves an injunction that issued at the conclusion of a case. With respect to the 4 infringing products, the Federal Circuit affirmed the injunction for 2 products, but reversed the injunction as to the other 2 products. Why the split? The Federal Circuit allowed the injunction of products for which the defendant had a non-infringing alternative. For the products for which the defendant did not have a non-infringing alternative, the Federal Circuit held that the injunction would be too hard of a financial burden on the defendant. So if there is not a financial burden on the defendant, then you may be entitled to an injunction. The ITC can issue something called a general exclusion order. Or in short, it's called a GEO. And a GEO is broad and prevents any infringing articles from entering the United States, regardless of the source of those products. And thus, a GEO is not limited to the parties named as respondents in an ITC action. Here, the ITC issued a GEO. Mayborn was not a respondent in the ITC action, but apparently imported an infringing product. After the ITC issued the GEO, Mayborn filed a petition with the ITC to rescind the GEO with prior art, showing that the patent should be invalid. The Federal Circuit found that the ITC properly denied the petition because the ITC only can consider invalidity issues during the course of an investigation and not after. So if you import any goods into the United States, you have to keep a watchful eye on whether the ITC institutes an investigation with respect to a type of product that you are importing, so that you're not in a situation where you cannot challenge a GEO. And in our last remedies case, the Genentech moved for a temporary restraining order against Amgen to prevent Amgen from selling a biosimilar version of Genentech's drug. Under the law, Amgen must give 180 days notice prior to marketing its biosimilar. Amgen did so, but after the notice was given, Amgen filed 2 supplements with the FDA to add a manufacturing facility and to change its drug label. Genentech argued that the filing of the additional supplements required Amgen to serve new 180-day notices, which would further delay the introduction of the biosimilar to the market. The Federal Circuit disagreed, finding that the notice provision relates to notice of the biologic product, and later filed supplements do not re-trigger the notice requirement.
Thank you, Jason. So the last group of cases we'll be discussing today concern PTAB practice. And we'll start with the Thryv Inc. v. Click-to-Call Technologies case, which was decided by the Supreme Court in April. In Thryv, the Supreme Court held that courts lack jurisdiction to review a PTAB decision that the one-year IPR time bar does not apply. In making that decision, the Supreme Court specifically noted that Section 314 of the AIA provides that the determination by the director whether to institute an inter partes review under this section shall be final and non-appealable. This ruling would, and the reasoning behind it, probably foreclose any attack on an IPR institution decision. And in the wake of Thryv, the Federal Circuit has been fairly routinely rejecting attempts to appeal institution decisions. In the ESIP case, for example, the court said that there is no review of a decision to institute despite a challenge that the petition failed to name all real parties in interest. In Cisco, the court found that there was no review of a discretionary denial of an IPR. And finally, in the SIPCO case, the Federal Circuit held that there is no review of a CBM institution decision. Next case we wanted to discuss is Arthrex v. Smith & Nephew. Now, this case was actually decided in 2019, but it's currently scheduled for oral argument before the Supreme Court next week. As you may recall, in Arthrex, the Federal Circuit had concluded that administrative patent judges provided for in the AIA were principal officers that would need to be appointed by the President and approved by the Senate in order to comply with the Constitution. This had not been done, and so the Federal Circuit concluded that administrative patent judges had not been properly appointed. It solved the issue by severing the portion of the statute that restricted the removal of administrative patent judges. Because administrative patent judges were terminable at will after that decision, the Federal Circuit reasoned that they were no longer principal officers, and there was no issue. They did not need to be appointed by the President or the Senate. The end result was that cases decided before the decision could be vacated and remanded to a new panel. Again, this case is currently scheduled before the Supreme Court next week, so we may get a preview during oral argument as to whether the Supreme Court agrees with the Federal Circuit's solution to trying to fix the constitutionality of the AIA. Now, a number of cases in 2020 did deal with the aftermath of Smith & Nephew. In Caterpillar, the Federal Circuit stated there was no need to remand where a PTAB decision, the final written decision, issued after Arthrex was decided. At that point in time, the panel had been constitutionally appointed as of the date of the final written decision, and that was sufficient. In Bolera, the Federal Circuit noted that Arthrex ruling also applies to decisions made by the PTAB in ex parte proceedings. So it's not just IPRs, CBMs, and PGRs. Finally, in Sienna Corp, the Federal Circuit found that a petitioner who had been unsuccessful at the PTAB was not entitled to a new panel. And the court said that Unlike patent owners, the petitioners actually had sought review by the PTAB, regardless of the composition of the panel. In its particular case, the petitioner had actually even moved to stay the district court proceedings while the IPR progressed. So essentially, the Federal Circuit found that the petitioner had waived any right to appeal based on the constitutional issues. The Bozeman financial case is one that Jason previously discussed with regard to Section 101, but it also raises some issues with regard to standing. In return mail, as many of you may recall, the Supreme Court had determined that the post office, as part of the government, was not a person and was not entitled to file an AIA challenge. In Bozeman, a patent owner whose patents had been found ineligible argued that the petitioner, which was the Federal Reserve Bank of Atlanta, was a government entity and not a person eligible to bring a patent challenge under the AIA. The Federal Circuit disagreed, and it concluded that Federal Reserve banks are not persons under the AIA. The court noted that they are chartered corporate instrumentalities, they're not government owned, and they are operationally distinct from any agency or department. The court also noted they may be sued directly in any court, including for patent infringement. The court also noted the banks don't receive congressionally appropriated funds, and the government only exercises limited control over the banks. It also noted the banks cannot promulgate regulations with the force of law. On a procedural note, it actually also had rejected the patent owner's attempt to incorporate by reference arguments that had been made in a separate proceeding. There were also a large number of precedential decisions from the Federal Circuit this year dealing with the issue of whether a party possesses Article III standing to appeal a decision from the PTAB. In other words, the issue is whether a petitioner has or is likely to suffer real injury from a PTAB decision that finds one or more claims patentable. In the first case, Grit had been previously sued for infringement. The case had been dismissed without prejudice. Grit subsequently transferred ownership of all of the products that were accused on the original action, and it hadn't identified any concrete plans for future activity. Despite this, the Federal Circuit held that Grit did have standing to appeal in view of the fact that the prior suit had only been dismissed without prejudice. In Adidas v. Nike, the court also found that they were standing to sue because Nike and Adidas are direct competitors, and Nike had accused similar third products of infringement and had refused to grant Adidas a covenant not to sue. The Federal Circuit noted that an appellant does not need to face a specific threat of infringement in order to have standing to appeal on an IPR. The takeaway from these two cases is that if you are dismissed without prejudice, you can still potentially file an IPR. And if a patent owner refuses to grant a covenant not to sue to a competitor, that may be sufficient to create standing to appeal a PTAB decision. The GE case involved another dispute between two direct competitors. In this case, they were competitors in the area of gas turbine engines. While GE hadn't been sued, the Federal Circuit found that it had standing because it had made concrete plans for future activity of a design that would likely be accused of infringement. GE was able to document that it had spent over $12 million researching the turbine that was likely to be accused, and it had in fact informally proposed the potentially infringing design to customers. On the flip side of that is the Argentum case, which presents an example of where standing was not found. Argentum had argued it was in the process of preparing to file an ANDA application with its manufacturing partner. That application was going to be filed in the partner's name. The Federal Circuit found that Argentum lacked Article III standing to appeal. It said if a suit is going to be filed, it's going to be filed against the manufacturing partner, not Argentum itself. It also found that Argentum had failed to provide specific evidence of investments in the generic drug or in the ANDA. The Federal Circuit noted that there were references to, quote, significant investments in manpower and resources in declarations, but that was not specific enough. It also found that Argentum's claim that it would suffer $10 to $50 million in damages from the delay of any ANDA were entirely speculative and conclusory. The Fitbit case also presents an issue of standing, and it's the standing to appeal an IPR in which a party is joined. Fitbit had filed an IPR challenging certain claims. It then joined another IPR that had been filed by Apple, and that Apple IPR included claims that had not been challenged by Fitbit. Fitbit then sought to appeal the PTAB's decision related to claims that were not part of the IPR that Fitbit itself had originally filed, but were part of the claims or were part of the IPR that it had joined. The Federal Circuit held that Fitbit's rights as a joined party apply to the entirety of the proceedings and include the right to appeal, even though Fitbit's own original IPR petition did not cover the claims that were the subject of the appeal. Now, the second case, ABS Global v. Cytonome, presents a very interesting way for a patent owner to possibly preclude the Federal Circuit from reviewing or overturning a favorable decision to the patent owner. Here, the petitioner had appealed an IPR that sustained the patentability of certain claims. 2 weeks after the PTAB had found certain claims were not unpatentable, the district court had granted the petitioner's motion for summary judgment of non-infringement. The patent owner then disclaimed any right to appeal the district court's grant of summary judgment of non-infringement and moved to dismiss the appeal of the IPR as moot. The Federal Circuit agreed that the petitioner's appeal of the IPR was now moot based on voluntary cessation. It noted that the petitioner couldn't demonstrate that it had any sufficiently concrete plans to engage in new infringing activities that were not covered by the patent owner's disavowal. So essentially, the patent owner was able to avoid a review of the PTAB decision. The next case, the Vidstream case, addresses what can be an important procedural issue in an IPR, whether and how a party can supplement its evidence supporting the public accessibility of a reference after filing of the petition. Here, the petition had included a prior art reference that had a date on it that said December 13, 2015. The patent owner argued in its opposition that the reference didn't qualify as prior art based on the date listed in the exhibit that had been attached to the petition. In response to the objections, the petitioner submitted additional evidence supporting the public availability, including a certificate of copyright registration that stated the date of first publication was from November 2011, as well as a declaration from an expert in library cataloging and classification, who was able to state that the record was created in August 2011 and modified by the Library of Congress in December of 2011. The expert opined that the reference was available no later than December 2011, which was before the challenged patent's priority date. The Federal Circuit here held that the reference qualified as prior art and that it was not erroneous for the PTAB to consider evidence that the petitioner had submitted with its reply to support the public accessibility of the reference. The HP case examines issues of estoppel as it applies to a party who joins an existing IPR. The case comes as an appeal from a district court decision which had granted judgment as a matter of law. The jury had reached a verdict of non-infringement and found that all claims were invalid as obvious. The district court granted judgment as a matter of law that the defendants should have been estopped from raising invalidity arguments based on their joinder to the prior IPR. The district court concluded that the arguments could have been raised in the prior IPR. The Federal Circuit disagreed, said the defendant, HP, was not estopped by virtue of its joinder in the prior IPR. In this particular case, HP would have otherwise been time barred from filing its own IPR petition, and it didn't have the ability to raise new grounds in the IPR because it was a joined party. As a side note, this case also includes an interesting issue about improper broadening of claims in re-examination. The court said whether a claim is broadened during re-exam is an issue of claim construction, and the court construed the same way both before and after the re-exam in this case, so there was no broadening. The Windy City case addresses the intersection between joinder and the time bar, and it essentially finds that joinder can't be used as an end run around the time bar. Facebook had brought IPR petitions against patent claims that were asserted by Windy City in litigation. After the 1-year time bar, Windy City amended its infringement contentions and identified new claims from the same patents. Now, these claims had not been included in Facebook's earlier IPR petition. Facebook then tried to petition for an IPR on the newly asserted claims under the joinder rules. Federal Circuit said that's not permissible. An existing proceeding can't be altered to bring in new issues that are otherwise time barred, and a party can't join a proceeding to which is already a party. So the takeaway from Windy City is that you may not want to limit the claims that are addressed by an IPR petition to those that are asserted by a patent owner, if there's any possibility that other claims might be added later. So the last issue we wanted to address is substitute claims. In Unilock, the Federal Circuit essentially blessed the PTAB's practice of denying substitute claims in IPRs, not only based on prior art, but also based on Section 101 and Section 112. So this means that patent eligibility, written description, and enablement are all possible reasons for denying substitute claims. The Nike decision, however, requires that if the board raises any new patentability issue sua sponte, it must give the parties notice and an opportunity to respond before issuing a final written decision. An interesting wrinkle in Nike is that the Federal Circuit specifically noted that it was not addressing whether the PTAB can look to prior art outside of the IPR record. The Federal Circuit specifically said it left that issue for another day. The language in the decision, however, seems to suggest that the board may have the ability to look outside of the IPR record for prior art. And I believe at this point, I don't see any submitted questions.
All right, thanks, Mike. We'll check very quickly our case count for the day. It's still going, it's still going. Let's see, how do we do? 74 cases in just over 60 minutes. Not too shabby. All right, we thank you for joining us today. If you are seeking CLE credit, please fill out the post-program survey with your bar number and the 2 CLE codes. The survey will show up in your internet browser when we end the webinar. Any additional instructions for CLE in your state will be emailed to you. We also will send an email to everyone with a link to the recording of the webinar, and a copy of the presentation is available upon request. This concludes our 4th annual 1 Year of Patent Law in 60 Minutes. We'll see you next year.
Thank you.
Thank you.